This is a special meeting of the Planning Board of the Township of Middletown pursuant to the Open Public Meetings Act and laws of 1975. The public has been notified that the Planning Board will meet on October 30th, 2013 at 6:30 p.m. in Town Hall. The Middletown Planning Board notified the Asbury Park Press, the Independent, the Star Ledger, and the Two River Times on October 25th, 2013. Notice of the meeting was filed with the Township Clerk and posted in the Town Hall on October 25th, 2013. All notification for this meeting was given pursuant to the Open Public Meetings Act at least 48 hours prior to this meeting.
Mrs. Lita, Mrs. Brightfield. Here. Mrs. Merrill, Mr. Bass, Mrs. Granahan, Mr. Hall.
Here.
Mr. Brightfield, Mr. Radford.
Here.
Mr. Simmons.
Here.
Mr. Sheets, Mr. Wilson.
Here. May I salute the flag?
I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Would you read the agenda, please?
The administrative matters, we have paying vouchers, our old business, the 2010-2022 for Monson Associates. There are no minutes.
No minutes. No resolution. And do we have any in favor of the vouchers?
I'll make a motion to approve the payment of vouchers dated October 30th, 2013 for a total of $7,208.03.
Second. All in favor?
Aye.
Proceed. Oh, we can go back here. Proceed. Okay, we can proceed. Mr. Burke, would you like to, how you would like to set up this meeting? And it's the public cannot participate, nor can any of the entities that were in this Four Ponds plan. We're just going to, this is going to be a discussion evening between the board members.
That's right. The board has available to it, and the members of the board were at the meetings in 2011 and 2012. In June 2012, there was a denial memorialized by a resolution in August 2012. That then went to court. As a result of that litigation, the judge, by an opinion on August 29 and an order on September 10, remanded the matter back to the planning board for review, reconsideration of the record that was developed before. No new testimony, no new evidence, no more public comment on the application, just for the board to relook at the record that was previously established and make new findings. We don't have Mr. Keeney here tonight, we don't have Mr. Greenspan here tonight because there's no new evidence, there's no new testimony. The evidence ended as of the end of the hearing on June 20, 2012. The applicant sent out notice under the municipal land use law, served and published it, I reviewed it, it's in order. In my opinion, that was not required, but to avoid any issue down the road as to whether or not it should have been noticed, they did notice, they did it voluntarily. Mr. Gazabrowski called me earlier today. He was representing the interveners in the lawsuit. There were parties to the lawsuit. Gazabrowski told me that he was not going to attend tonight. I was over to the attorney for Four Ponds Associates, the applicant in this matter, who was going to attend tonight, but I don't see him here. If he comes in, we'll make note that the attorney is here representing Four Ponds. And as of this time, a little after 6:30, there were no attorneys here representing either the interveners or the applicant. So you should have in front of you or available to you, or you lived through it, the transcripts of the various meetings, the judge's opinion, the judge's order, and the prior resolution of the board. We also have the exhibits from all the board meetings are behind us here, all marked. And if anyone wants to refer to any of those as we go through, what the judge is basically saying is, he wants to hear from the board, what are your opinions, discuss the matter further. After we do that tonight, the board does that tonight, I will then draft up a resolution, send it out to the entire board for its review. And we have a regular meeting next week, next Wednesday night, and at that point then the board can adopt the resolution. And I'll draft it up in accordance with your instructions tonight as to what your, anticipated decision is. Because the judge wants discussion tonight, normally the board discusses and then votes. Because of the rather unique procedural circumstances we're in, it was my recommendation that the board tonight discuss, give me the opportunity to draft up a resolution. I can circulate it for comment, review, changes, edits, whatever the board members may desire, and we can have that available for the next meeting. So that the way that I had anticipated would be that there'd be no vote tonight, but there'd be a clear direction from the board as to how that resolution should be prepared on the remand that was ordered by the board.
Mr. Berman, I believe we all looked at the judge's opinions and read it thoroughly. We all read it thoroughly. I have some opinions, and I'm sure many of the people on the board here, maybe we can just go one at a time and discuss, have a generalized discussion. Who would like to start?
Mr. Gorman, I read your letter of October 11th, and I guess going back to the last meeting that we had where we took testimony from Mr. Litwarnia.
Can I make a comment there? On the October 11th meeting, that, in my opinion, that memorandum to the board is privileged and confidential, not part of the record, and was legal advice and legal opinion to the board as to where the litigation left off and what the options were at this point in time. So, I don't want that to be a public document or to be out in the public domain. That is privileged communication between me and the court. So if we read from it, it becomes non-privileged. So
Let me restate.
thank you. And then just for the record, Mr. Harrison is here. William Harrison representing the applicant for bonds.
The testimony from Mr. Litwarnia and Mr. Zimmerman was fairly compelling and probably was the genesis for myself making a suggestion that we deny the application. I don't disagree that probably the stronger testimony was from Mr. Litwarnia, and that pertained to all of the RSIS deficiencies, leave it at that. So I don't know how the rest of the board feels, but it would seem to me, at least I would agree, that should form the basis for the new resolution. And the only thing I'll add to that, and I'd like the board's opinion on this. I don't know whether we should cloud issues before the judge at this point. I don't know whether we should introduce additional issues. I mean, obviously we're limited in terms of what we can do, but the one thing that disappointed me was that, and I know this application needs DEP approval. I went through, literally a year's worth of notes, and one of the issues that I thought was compelling were environmental issues. I know there was an environmental impact study. I know this ultimately will require DEP approval, but in the testimony, and I forget who it was that testified to this, they mentioned that all of the runoff from the non-pervious surfaces, particularly the roofs of all of the dwellings, which, if you look at the footprint, is larger than the existing building. All of that runoff would go into Swimming River Creek. And I just can't conceive, this is the one-year anniversary of Hurricane Sandy, and being very familiar with Swimming River Creek, I wouldn't want to live downstream. Now, I don't know whether that's an issue that should be brought up. I don't know whether we should just leave that to DEP and stick to the RSIS deficiencies, but I just thought I would throw that out.
Mr. Hall, I do concur with what you've said. One of the things that bothered me with the RSIS waivers, as everyone saw on this meeting, there were two upper roads. And Mr. Livornia, in his testimony, gave us facts of the narrow width of these roads. They're about 24 feet. They really should be about 30 feet. Or maybe it should be one road. But we discussed fire safety, getting an engine in, first aid. My own consideration why I turned this down was I'm not a baby boomer, but a before baby boomer who lived in housing, VA housing, when my dad came back from World War II. And this reminds me of VA housing. It really does. It's cramped, it's blocked. We cannot tell the judge or the state of New Jersey that we don't like it for aesthetic reasons. But I do not like it for the safety concerns of the people who may eventually live here. Environmentally, I do feel we'll add a lot of water and a lot of sewer to the systems, and it will have to be paid by someone. I do hope it is the Four Ponds Corporation. But that's one of my major regrets. It's a great idea, it was a beautiful, but it's a lot of homes. But safety, the narrowness of these roads, it's too tight. Also, I always like to make sure people have recreation. There's not enough recreation here. There's not a ball field. Kids have to walk 3/4 of a mile to go to a baseball field. I don't like it. And that's why I denied it in the first place. But I denied it mainly for the rhesus contingencies of the way traffic is laid out.
For the record, the chair is referring to Exhibit 010, which was an exhibit that Mr. Livornia had prepared and presented to the board. If we could, I just want to clarify. The two RSIS exceptions that Mr. Livornia identified is not for the narrowness of the roads. That's not one of them. It's the distance between Road C and Road A. Mr. Livornia cited an RSIS provision that had to be 150 feet apart, and they're roughly 40 feet apart. And the board has the testimony, but at some point he called it dangerous or unsafe or something like that. He also cited the terminus of Road C, where it loops around back to Road A, and that angle, in his opinion, created dangerous or unsafe traffic conditions. Those are the two RSI exceptions as to the road design that Mr. Livornia cited. It's not the width of any of the roads. There is an RSIS waiver. The RSIS standard called for 28-foot roadway width. They're at 24. The RSIS standards, as it was explained during the hearing, as I understood it, and as it was litigated, was that they could have 24, but without parking on the road A. So I don't think there was any particular dispute as to the width of the roads. But other issues, and I appreciate the chair's concerns. The issues concerning sewer, density, attractiveness, the overall number of units, the size of the recreation area, all those areas, I think it's fair to say, looking at the opinion and looking at the law, those are beyond the purview of this board. Those are issues that are either under DEP control, or those are issues that were considered or should have been considered at the time that this matter was zoned for its now permitted use. So I appreciate the concerns. I'm not too sure that those would be valid reasons to put in a resolution. If the board were inclined
RSIS standards, those other things may not add all that much and may detract from an ultimate decision by the board.
If I may, my comment just actually is going to be about Mr. Warnia's comments about those exceptions. I think it was treated intersections at less than 150 feet and some other intersections of roads that created hairpin turns that seemed to be very, serious safety issues. And I believe, in going back to the testimony, all the developers really didn't offer any proof against it. They made one blanket statement that they, complied with all the RSI standards, but really didn't have a comment back to the safety issues that Mr. Warnie brought up. Those the intersections less than 150 feet and those hairpin.
Yeah, I agree with that.
There was also a very weak rebuttal from the Four Ponds attorney. Very weak, and if anyone was here, we didn't see a strength of his ideas of why we should go his way. He did not have a strong rebuttal, and there weren't enough facts. Here is why. This is why. This is this. We did not feel that sitting on the floor. At least I didn't. I don't know if anyone else did. I did not feel the rebuttal was strong enough for the Four Ponds person.
Well, further than that, in reviewing Mr. Warnie's testimony, specifically cites sections of the RSIS with the angles of the turn described as being completely unsafe. I went back and took a look. I couldn't find any testimony or evidence from any of the experts from the applicant that rebutted that. So I found that to be the most compelling issue.
And I think within the judge's opinion, Judge Catalco does, and I can't put my finger on it right now, but on page 15, the judge says, well, plaintiff, Four Ponds, argues that its experts adequately address the RSIS standards. It does not appear that the cited portions of the transcript contain testimony concerning the 40-foot distance requirement between intersections. And there's nothing here specific about the other angle issue on Road A in River City, but I think the judge recognized in his opinion that there really wasn't anything submitted in the record by Four Ponds to rebut the testimony from Mr. Warnie. I think what the judge is asking for is that he wants more specific findings and that the prior resolution wasn't enough for the judge to feel comfortable with findings from the board, or perhaps maybe more importantly the way I expressed them. So the judge is saying, tell me again more clearly what decision the board is making and why you're making that decision. These comments that I will be helping to form that basis for a revised resolution.
Looking at the June 20th meeting, which was the last meeting, we could see point blank that the evidence wasn't there for Four Ponds. The objectors or interveners actually had given us a more clear and precise discussion of where we should move. Anyone else on the floor?
See, if I'd like to take a moment to draw a straight line conclusion with regard to the RSIS deficiencies and why those RSIS deficiencies were not rebutted by the applicant. They were as a result of the design that was put forward. And so let me take a couple steps back. Number one, there's 68 acres on the site. The site is not all uplands. It's a combination of uplands and wetlands. Therefore, the applicant was unable to evenly distribute all of the proposed 342 units on all of the 68 acres, but only some of the 68 acres that were uplands and not wetlands. So that started to generate some of the issues that created the RSIS deficiencies. What does that mean? That means that the 342 units that were permissible by ordinance were now placed onto a much smaller area, creating a higher density within a density, if you will. When you do that, you start to create other issues, and you generate, because of the fact that you're now placing those 342 units in a smaller area of the site, because that area is the upland area as opposed to the wetland area, you begin to create issues and deficiencies in accordance with our RSIS. And as referred to by some of the comments of the other members, those deficiencies create safety issues which can or would have been rebutted or abated if the applicant had done a number of things. Number one, proposed far fewer units, or number two, had the ability to more evenly distribute those number of units throughout the site. So it is fully my contention that based on the division of uplands and wetlands, based on the fact that the applicant desired to place the full 342 units on a smaller area of the site, that has created RSIS deficiencies, which create safety concerns, which by the applicant's own lack of rebuttal testimony has not modified, changed, or altered in any fashion. And that causes me to believe that the fact that they want to place 342 units on a smaller area of the site creates these deficiencies, creates a safety issue, and is my prime objective for my denial of vote for this application.
Very well said.
Based on what we've discussed, and in light of Judge Picalco's direction, it would be my recommendation that we create a new resolution that more specifically zeroes in on the RSIS violations that were cited by
And safety issues, as Mr. Sedembrino said, it was a much smaller situation, a smaller group of townhouses, it'd be a little different story, but this is too tight.
I'm sorry.
Well, I agree with everything you said. The only thing that flies in the face of that is the zoning and the rezoning of 8 units per acre, I think, or 7.1, which begs the question, and I've had discussions with other people, I wasn't on the committee when they rezoned that property, but what goes into that decision when it's made to rezone, the density that they permitted on that, which I think personally was too high, based on all of the environmental issues, and as you said, based on the developable land there. So, I don't know if enough consideration was given when it was rezoned for that use, but I don't know that that's an issue before the judge.
Yeah, let me, if I can. The zoning and the density out there was established by the zoning ordinance, so that, I think what Committeeman Sedembrino's point was that the development is all concentrated in one particular area, creating some of the RSIS deficiencies, and that if they had more area, they perhaps would have more room to spread those roads out and make them,
Or fewer units.
but they're entitled to the number of units. That cannot be the basis for denial.
Keep in mind, they're entitled to the number of units, but they're not entitled, if those units generate deficiencies or create safety issues, they're not entitled to do that. They can certainly try, but it will be my objection and position that those number of units in that area of the site create items that they have not rebutted, or they have not appealed, modified, or mitigated at any time during the application. So frankly, they've created their own issues, and since they only have a certain area of uplands as opposed to wetlands, some of the resolution would have been to make it a much smaller development. The applicant has selected not to do that, so again, it's certainly my position that that has created those issues that are difficult for me to overcome from a development point of view.
I agree. It is a legal matter, and I want to make sure we go forward on the basis that we're grounded in the law, grounded in the judge's opinion, and grounded in the record that has already been established. If the applicant can fit
342 units, and complied with RSIS, he's entitled to do that.
Good point, but
Well, he hasn't demonstrated it so far, but he might be able to, and he didn't take the opportunity last time. The applicant did not request at the end of a year plus hearing, say, let me revise it. They went ahead and asked for a vote. They got a vote.
we have an
RSIS outside.
established record that we're working off of, and the record that exists now, as I said earlier, it reflects violations of the RSIS with no rebuttal, no comment from the applicant. So I think our narrow focus, the narrow purpose of this meeting, so the Judge Capo's ruling was to review and once again consider all the information that's put before us that's in the record and come up with a more specific resolution. And I think based on our conversation here tonight, I think that the issues with the RSIS and set forth in Mr. Warren's testimony, I think should be more specifically set forth in a new resolution. Give back to Judge Capo.
With the comments so far, I understand the board's direction. I'll try to get out a proposed resolution to the board tomorrow for Debbie. I don't know if that I'm going to be able to get it done. Depends on how tomorrow goes, but I'm going to try to get something out by the end of tomorrow. And the board will then have it for 6 days or so, depending on when it's delivered, how it's delivered to everybody. But everybody will have it for a vote on the November 6th meeting based upon the resolution that you'll have before you will be in denial, primarily based upon the RSIS exception.
Does everyone concur?
Yes.
No, so tonight is not a formal action by the board. The formal action will be done with the resolution before the